Welcome to Employee Benefit Plans and Business Sense.
Hello and welcome back to Employee Benefit Plans and Business Sense with Lank and Kathleen Salas Bass of KLB Benefits Law Group. And Kathleen help employers and benefit plan service providers navigate the complex legal requirements of employee benefit plans. With decades of combined experience in employee benefits law, they guide clients through compliance matters, corrections, IRS, and DOL audits. I'm your host, Lisa Mosbey, and today we are talking about domestic relations orders and how they affect retirement plans. Ladies, thank you so much for joining me today to share your experience.
Hi, Lisa. It's great to be here.
You know, Kathleen, I want to start with a definition. Can you tell us what QDRO is?
Yeah, QDRO, it's an acronym that stands for Qualified Domestic Relations Order. And what that is it's a court order which basically divides up a certain amount of participant's plan awarded to a non-participant. And this usually happens when there's a divorce, so that some of the participants' retirement plan can be awarded for purposes of division of marital property or child support or spousal support.
And then when is QDRO required and why?
Well, that's a very good question. A QDRO, someone can't just walk into their employer and hand them the divorce settlement and say, we got to divide up my plan account. And the reason for that is that ERISA has what's called an anti-assignment provision, which says that, a third party can't be assigned an interest in a participant's retirement plan. And so, a creditor can't just say, well, you owe us this much money. We're going to attach your retirement plan assets in order to get repaid. So the exception for that is where there is a QDRO. And again, that's where there's a domestic relations order, and the domestic relations order is issued to the plan. And so it's something that just is required under ERISA. And so it's a very sort of special creature in itself.
Again, I want to help folks understand clearly. Can you tell us what ERISA is?
Sure. ERISA is the Employee Retirement Income Security Act of 1974. And that's basically a large body of law that works alongside the Internal Revenue Code, and it governs governs employee benefit plans, including, not just retirement plans, also health and welfare plans.
And then, Kathleen, does the plan have to do whatever the court order says?
You would think so, right? It's a court order. It's something, you think, okay, the plan has to do what the court says. But that's actually not true in this case. What happens is, if you think of the name Qualified Domestic Relations Order, well, the plan administrator is the one who determines whether it's qualified or not. So even if they are sent a court order, already filed and approved by the court, if there's something in that order that doesn't meet the ERISA requirements or creates potential liability for the plan administrator gets the last word on whether it's qualified or not.
And again, mentioned retirement plan administrator. What does a retirement plan administrator have to do when it receives a QDRO?
Again, another good question. And even if the plan administrator gets notice that a QDRO or a proposed QDRO is coming, usually we have it, we say if it's written notice, you don't want water cooler talk triggering this, but once they get written notice that a QDRO is coming, or they get the actual QDRO, then they need to notify the parties. They need to make sure that both the participant and the what is called the alternate payee, the person who is got the interest in the other part of the participant's account, they have to notify both parties. And if they have counsel, if the plan administrator knows that they have legal counsel for the order, they've got to first, they have to notify them through their legal counsel. So everyone gets a notice that this is happening. And then what has to happen is that the plan administrator needs to freeze the participant's account. I think we all know that divorce is a very emotional, fraught, and sometimes chaotic situation. So you don't want the participant to, in anticipation of the division of their retirement account, taking large distributions out of, or large loans, things like that will make it either reduce the amount that the alternate payee gets under their order, or it makes it impossible for the plan to pay out the full amount. And so that's the second thing is, once you notify everyone, you need to put a freeze on the participant's account. Then they need to review the QDRO and follow their QDRO procedures for reviewing it. And then once they make a determination as to whether it's qualified, then they need to, notify the parties, hey, we've determined that this is qualified. And then, they can send out distribution materials to this alternate payee, or, kind of proceed with actually, following the order at that point.
So Kathleen, who prepares the QDRO?
Well, generally speaking, the divorce attorney, either for the alternate payee, which is usually the case, or the participant. There are also service providers out there who all they do is they prepare QDROs. They might be paralegals, but their whole business is drafting QDROs, and so they're kind of an independent entity that is actually preparing the QDRO. And sometimes the parties want to go that way rather than having one or the other's attorney sort of drive it.
I understand that. And then what are the minimum requirements for a domestic relations order to be qualified?
First of all, there are some things that in ERISA which specifically say, like, you have to have certain information about the parties, the name of the plan, and the formula, the dollar amount or the percentage of the account that goes to the alternate payee. And it also has to not do certain things. And those certain things that it can't do are, it can't ask for a type of benefit that the participant isn't entitled to. It can't ask for an amount that is in excess of the account. And it also, it can't require sometimes there is more than one QDRO involved with the participant's account. So it can't require payment of participants' assets to the alternate payee that are already the subject of another QDRO. And then just as an attorney, I think I would say this is very important, that whatever that formula for dividing up the account has to be very, very clear. And this is just one of those things, it's not spelled out in the law. It's just like, this is, my advice is that you don't want to have anything that's ambiguous in that formula, and then have the plan pay it out. And then one of the parties comes back and say, well, you paid too much to the other person. You need to make that money up to me. So, that's one thing that during the review process, they need to make sure that it's very clear exactly the amount that the alternate payee is entitled to. And sometimes, and also that the plan, has the information, the data that they need to actually calculate that amount. And so if there's a problem with that, then they need to tell the parties it's not qualified until that is clarified.
I understand qualified, Kathleen, but are there some best practices for both parties involved?
What I would say is that they need to find a very qualified individual to draft the QDRO, the order. And then I would recommend that they send a draft to the plan administrator before they actually submit it to the court, and sort of get pre-approval. And that way, if there are any problems, they're not having to incur the expenses of filing it with the court again. And, there's expenses for the preparation and filing, and there's also probably court fees as well. So the best way to do it is just get that pre-approval conditioned on filing it with the court. So,
and from the other side, are there best practices for the plan administrator?
Oh, definitely. First of all, ERISA requires that every plan have written QDRO procedures. So, it's important that they have the written procedures, because they have to give them if like an attorney or a participant or an alternate payee asks for those, they have to be able to provide them. And they should have someone also very qualified to review any orders that come through. And it can be an attorney, which I always recommend. But it might be in-house counsel. And I always recommend that the third-party administrator be involved in the review, because they're the ones that know whether they can definitely figure out the amount. And a lot of times when I review QDROs, the TPA will say, "Oh, we don't have records for this period," or this is asking for more money than this participant has in the account. So then, so that is one of those things that it's, sort of a team effort there. But I would definitely say that, a plan administrator needs to have qualified people helping them with this. And also, that they make sure they follow their QDRO procedures. And then, some employers that I know, they even have an attorney draft a sample sort of ideal QDRO form, and that can be provided to the parties and their attorneys. And that way, if the attorney, like say the whoever's preparing the QDRO uses that sample QDRO, then when the person on the plan administrator side actually reviews it, they know, they can see, oh, this language is the same as in our sample QDRO. They know it's already, it's approved. So it's faster, that both sides know that it's meeting those requirements, that they both, that the QDRO has the provisions that the plan administrator wants. I also recommend that because sometimes there are protective provisions in a QDRO that, the plan administrator would like to see, like indemnification. If they do everything right, but something goes wrong between the parties, that the plan is held harmless. Well, that's not something you can not qualify a QDRO for if it's not in there. But if you're controlling what the language is, you can have things like that in there. So that's a very good practice for plan administrators to follow.
Kathleen, I want to tie this all together for our listener. Can you share an example where a QDRO caused a problem and how it was handled?
Yeah, oh, definitely. I mean, frequently, what the problems that I see are in that formula or the dollar amount, where, for example, they say, we want you to divide up, 50-50 the account as of the date of the divorce. But that divorce was years ago, and they're just now getting around to doing the QDRO. And then the third party administrator no longer has the data to determine what the balance was on that specific date. So then we have to go back and say, this is the situation. We don't have this data. We can do it as of the end of that year. So, we need you to write it differently so that it says that, the date of division is going to be the end of that year, as opposed to a specific date during the year, just because we can't determine the balance. And I think, what happens in those cases is the plan administrator has to reject the order and say, this is how you need to correct it. It's always good for the plan administrator when they reject it. They need to tell them, this doesn't meet this requirement, and this is what I suggest you write. And, because that way it speeds up the process. It helps, you're not playing any games here. It's just, this is what we need to see because this is the data we have. So that's really how I recommend participants handle it, or have their legal counsel handle it.
I think that's where we'll wrap it up for today's episode, Kathleen. I want to thank you for sharing your expertise and guiding us through this. These are complicated processes.
It is.
It's very
and it can
helpful.
Be very dramatic.
It can be, yes. And to our listeners, thank you for listening to Employee Benefit Plans and Business Sense. If you're dealing with a domestic relations order, or you want to make sure that your retirement plan is handling these situations correctly, visit klblawgroup.com to connect with Dahl and Kathleen. Be sure to leave a review, and subscribe to the show so you can come back next time. We'll see you there.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.